Pause right here because this is the first crack in the foundation of the entire case. What you're watching isn't just confusion. It's a legal identity crisis, commercial lease or not. That distinction matters everything. Commercial tenants usually don't get habitability protections the way residential tenants do. So when she tries to straddle both positions, the court sees uncertainty.
She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent, pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer, filed with this court, had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023, which is his duty under the terms of the lease for agriculturally zoned properties. Erica Ward.
You can't have it both ways. You can't have it both ways. If you're going to claim, and counsel, before you go on, I think you need to do your research. If you're going to claim that this is not a commercial lease,
Yes.
it's a 7-year lease,
Yes.
then the obligations regarding repair change.
That I think that would be something to bring up by the plaintiff to rebut what I'm saying. Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste.
Here's the pivot. This is the tenant side playbook. Withhold rent, make repairs, deduct costs. It can be lawful, but only if the lease type, jurisdiction, and notice requirements line up perfectly. The problem? The opposing side is already framing this as unauthorized self-help, and once that narrative sticks, the tenants aren't victims anymore. They're defaulters. That line
Interference with her use of the property, which had caused her damages. This complaint was filed
I don't know why I need to know all of it.
because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem. Counsel, that is what I indicate. If you don't see it as a problem, then so be it. But I think on its face, it's a problem. Any question regarding your ethics is your own. Because I'll tell you right now, if an attorney comes before me and I think that they have done something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that. So don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're going to be found in contempt. I'm done with scope.
Yes.
What I said
Hate to ruin his rant, but he did question our ethics and should have.
to you and what I was indicating is that you took, as you stand before me, the warrants are your clients. What I am then told is that you took funds that would have been client funds and somehow took them into your possession.
line right there, that's judicial shorthand for pick a lane. Courts don't allow legal Schrodinger's cats. You don't get residential protections, and commercial flexibility. The judge is signaling impatience now. When a judge starts correcting legal theory mid-argument, momentum is already slipping away.
Redistribute. Your argument may be that you did it for other reasons.
I would like to state facts behind the assumptions that I took client funds. I did not. Erica told me that she wanted, I was consulting with her as a property manager. I was not her attorney.
Then if that's your position, that's your position.
That is a horribly stupid position. By the way, you can't do a bunch of stuff prior to representation and then take on the representation. That would be a reason to say, nope, I have a conflict. I cannot now represent you. This cutesy game, I don't know if she believes herself, but this is absolute garbage. I feel sorry for her saying that openly in public.
From the court's perspective, it looks different, which is what I was pointing out.
Yes. And
if I want to make an accusation, Ms. Stowe, I am not shocked. I will clearly make that accusation, and I have not.
You were very clear that it was not an order, it wasn't an opinion, it was words. But I tell you that words have consequences because we are on YouTube.
So does one's actions.
Yes. Yes.
Whether you're on YouTube or not, it doesn't matter. This is a public.
Yes.
And all I am telling you is that the court saw concerns.
Yes. And I am here to address the concern so that...
This is the temperature shift. We've moved from legal disagreement to courtroom discipline. Once a judge warns, about contempt, the substance almost stops mattering, tone does. And notice the word choice, dramatics. Translation. The court believes emotions are replacing legal precision, and that never ends well. Brutal.
On the record as well, so that...
No. I have given my admission at the last year. The wards may proceed in whatever fashion they wish. May proceed in whatever fashion you wish. If I thought you were doing something, I would myself remove you from the case. I have not done that. So I'm done with this.
Today. You are done with me today, or...
Well,
Thank you.
Your Honor, the first I'm hearing about a rent property time that's doing rent payments. I don't know who the property management is. I don't know what the bank account is. You want tenants to produce an accounting. They did that. It's a mess. And my client is the one who's being purchased by them. Actions do have consequences. And the consequences of their agents for the actions by tenants and agents have consequences. And they do have the right to withhold rent payments. That's what they did. These are grounds for default on the lease. The lease should be terminated, and they have to deal with the consequences. Now, at tenants, they may have their own report separate from this action. That's their decision. That should not be my client, and my client shouldn't have to keep fighting over alleged ethical violations.
They did not have the management agents. She consulted with me about my opinion for over 3 years. I had no jurisdiction over...
But strategic. From the court's perspective, this isn't about insults. It's about conflicts of interest. You cannot consult as a property manager, touch funds, then later claim attorney distance. That's not clever, it's combustible. Even if no rule was technically broken, appearance alone can sink credibility. And here's the
property. It was completely Erica and Aaron's tenancy, and I was not their attorney.
So,
By their property.
so,
Yes.
it's those statements that give the court pause. When you're saying that they consulted with you regarding the property, and
Not in my capacity. I was taking writing lessons, and she was telling me what was going on, and I gave her some of my advice, but not in a professional or proprietary or contractual meeting.
okay.
As a friend.
I think Ms. Hope's property should manage company the company should be a party. She asserted herself into this litigation and went from a simple non-payment of rent and has ballooned because of tenants through their counsel's actions. And that's the comments.
We filed, the court case was filed July 9th, long before this court had jurisdiction. In my first response as the attorney for this court, I asked for an escrow fund to be set up, a trust fund to be set up by the court. Then you did that. Anything done before that was not in. There was no money put in any trust fund.
Yes. Ms. Hope, let me just ask this. Counsel,
I need to start close here.
we can get the equipment correct? Counsel, are you going to file a motion to add Ms. Hope and this as a party to this action? I realize I'm asking you on the spot because you're first hearing about it, and I know that there would be things to be taken into consideration in doing it.
Obviously, I'd have to discuss my clients. Something that I would like to avoid, I think the language of the contract is clear that you do have the right to withhold payment. These are grounds for default, and that the lease should be terminated and there should be an eviction order.
The smoking gun. One signatory, one account. Tenant funds. Whether she intended wrongdoing doesn't matter. The risk profile just exploded. Courts don't need proof of misconduct to intervene. They need potential harm. At this moment, the case stops being about rent hand, becomes about control, authority, and trust.
If we have to keep going this back and forth way, we may have to. Especially the third party that's handling funds, handling the rent funds, then we would have to.
No?
So,
Yes.
were you the property manager for them?
No.
Were you involved in the payment of funds to contractors?
Only in the account that Erica used to withhold funds. And
What do you mean by that? Who were signatories to that account?
Erica approves all.
Who were signatories to that account?
I was
There's a problem.
not my attorney.
So, no. That's a problem. So, Who else was a signatory of our account?
How about myself? Me and me alone. And
Right.
money was filed after we filed this with the court case.
Oh, doesn't matter.
And this court
Doesn't matter. It doesn't matter. It doesn't matter. Do you not see a potential problem with this now? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it. And I don't see a legal problem. So when you say it's a problem,
Yes.
yeah.
It's the right information. Congrats. But do you believe that